Let me ask you something. If two people both cause someone's death, same act, same outcome, should they face the same punishment? Most people would say no, but most people couldn't tell you exactly why. The law can. And today, that's exactly what we're going to break open. Welcome to Narrator, Analyst, Practitioner, Scholar channel. I'm the narrator. I hold the thread of the conversation. And today, I have three people sitting with me who are going to make this episode something special. Let me bring them in.
Happy to be here. I'm the scholar. My work is in the history and philosophy of criminal justice, why laws exist the way they do, what they're trying to achieve, and what they reveal about the society that built them. Today's topic is one that I find endlessly fascinating.
And I'm the practitioner. The scholar asks why the law exists. I deal with what it does to real people on real days in real courtrooms. Sometimes those two things align perfectly. Sometimes I think they really don't. Good to be here.
I'm the analyst. I look at the law as a system, its structure, its logic, and whether the design actually does what it's supposed to do. When the scholar and the practitioner disagree, I'm usually the one trying to figure out where the gap between theory and reality actually lives.
Three perspectives, one conversation. And the question sitting at the center of all of it today: when does killing become murder? Let's find out. Part 1. How the law gets moving. Before we can talk about murder, we need to understand something more basic. How does the law even get set in motion when a crime occurs? Analyst, take us there.
So the very first thing the law does, before courts, before trials, before any of it, is classify the offense. Cognizable or non-cognizable. A cognizable offense is serious enough that the police don't need to wait. No warrant needed to arrest. No magistrate's permission needed to investigate. Murder, rape, kidnapping, robbery, dacoity, dowry death, rioting. These offenses affect society gravely. The law moves first. It does not pause.
And the other side.
Non-cognizable. Public nuisance, simple hurt, minor mischief, trespass. Here the police need a warrant to arrest and magistrate approval to investigate. The citizen has to speak first. The court is the one that sets things in motion.
Narrator, analyst, and in practice, what ties all of this together is the FIR, First Information Report. The moment information about a cognizable offense reaches the police, it is written down, recorded, signed. That one document is the starting gun for the entire criminal justice process. I've seen FIRs filed at 2 a.m. under a single flickering light. The law doesn't keep office hours.
And practitioner, what sits behind that classification is actually one of the oldest tensions in legal history. How much power should the state have to act without asking permission? And where does the individual's protection from that power begin? The cognizable and non-cognizable line is this system's answer to that question. Legal systems across the world have struggled with that same balance for centuries.
And as we move through today, that classification matters, because murder sits right at the top of that cognizable list. Part 2. The crimes that stop halfway. Scholar, there's a category of offenses the law deals with that I want to make sure our listeners understand. Crimes that were never actually completed.
Yes, and these reveal something deep about why we punish at all. Inchoate offenses, when the word means incomplete. Attempt to murder, criminal conspiracy. Abetment. The intention existed. The steps may have begun, but the final act never happened. Punishment is generally less severe because the completed harm was never realized, but the law does not look away, because a dangerous intention left unaddressed has a habit of becoming a completed one.
Contrast that with complete offenses, murder, theft, rape, where every element is fulfilled. The act is done. The harm has occurred. The full weight of the law applies.
Scholar, analyst, abetment cases are some of the hardest I've encountered. Because you're standing in court asking a judge to punish someone for what they intended, when their hands never finish the act. The harm is real, the intention is real, but the completed act is not. And yet the law says that is still enough to answer for. I think it should be. The stage of the crime shapes the sentence, but it doesn't erase the responsibility.
Part 3. 2 pillars, 1 crime. Analyst. 2 Latin phrases sit at the foundation of almost every crime in the books. Explain them the way you would to someone hearing them for the very first time.
So, criminal law, almost universally, requires 2 things to exist at the same time for a crime to be established. Actus reus, the guilty act. What did the person physically do? That could be a direct action, hitting, stabbing, shooting, stealing. It could be an omission, a person who fails to do something when the law required them to. Silence can be a crime. It could be a state of affairs, being in possession of illegal substances, and mens rea, the guilty mind. Did the person mean to do it? Put them together. Crime equals actus reus plus mens rea. That formula is the backbone of criminal law.
And narrator, in court, that formula is everything. You have to prove both. The act is visible, the mind is not. You cannot hand a judge the accused's intention as an exhibit. You rebuild it from how they behaved before, during, after, from what they said, from what they chose not to say. The reconstruction of a person's mental state is where the hardest legal battles happen.
And what makes mens rea so powerful, narrator, analyst, practitioner, is that it is not a single fixed thing. It lives in degrees. Intention, fully deliberate, you meant it. Knowledge, you didn't plan it, but you were aware of what would follow. Recklessness, you knew the serious risk and proceeded anyway. Negligence, you failed to meet the standard of care a reasonable person would have maintained. The higher the degree, the graver the crime. The mind behind the act becomes the measure of the punishment.
So the same physical act, a person dies, can mean entirely different things in law, depending entirely on what was happening in the mind. That is the thread running through everything in today's episode. One final thought from each of you. Scholar, any concluding thoughts before we close the discussions?
What strikes me most every time I return to this question is that the law's insistence on looking inside the mind is actually a profoundly human act. We don't just punish outcomes, we punish intentions. That distinction between the person who meant to kill and the person who didn't is what separates justice from mere consequence. And that distinction is ancient. It predates every code of criminal law we've discussed today. The law didn't invent the idea that intention matters. It inherited it from something much deeper in us.
I'll say this. Everything the scholar and the analyst have laid out today, I've watched it play out in real rooms with real people whose lives turned entirely on these distinctions. A word, a classification, a degree of intention. The difference between murder and culpable homicide is not academic. It is the difference between what a person carries for the rest of their life. That weight is why precision in law is not a luxury. It is a moral obligation.
The system we've walked through today is imperfect. Every system is, but its design is deliberate. Gradations of intent, thresholds for state action, degrees of culpability. These aren't bureaucratic details. They are load-bearing structures. Pull one out carelessly, and the entire architecture of fairness begins to shift. The question isn't whether the system is perfect. The question is whether it is honest about what it's trying to do. Most of the time, I think it is.
When does killing become murder? The answer, as you've heard today, is never just about the act. It's about the mind behind it, the intention that preceded it, the knowledge that accompanied it, the system that receives it. The law doesn't just ask what happened. It asks who you were in that moment and what you chose. That's the work. That's always been the work. Thank you for listening.